Welcome. Thank you for joining me for this video about tools for resolving special education issues. Michigan Alliance for Families provides information, education, and support for families who have children and young adults birth to age 26 who receive or may be eligible for special education services. There are several tools that can be used to resolve disputes between parents and school teams. The hope is that through effective ongoing communication and use of these tools that the issues can be resolved before filing a state complaint or due process complaint. Tools for resolving special education issues include informal meetings and meetings to review and revise the IEP, facilitated meetings, mediation, state complaint, and due process complaint and due process hearing. I'm going to discuss each of these in more detail. The Individuals with Disabilities Education Act and Michigan Administrative Rules for Special Education encourage informal resolution of disagreements between parents and school teams. The most effective options involve early and meaningful communication in a collaborative manner. If you have a disagreement or issue of concern regarding your child's education, you are encouraged to reach out to the teacher, principal, or special education administrator as soon as possible. An informal meeting or meeting to review your child's IEP might be a good starting point to discuss your child's needs and your specific concerns. These informal or IEP review meetings are scheduled at a mutually agreeable time and are conducted usually by school personnel. Informal meetings allow parents and schools to work together, preserve relationships, and avoid costly hearings. This option also allows decisions to be reached faster without intervention from a third party. Informal meetings can be used to discuss any topic and are not limited to special education issues, and anyone can be involved in an informal meeting who may be helpful in getting the issues resolved. For example, the principal, an administrator, a gym teacher, or an outside service provider. A meeting can be held specifically to review or revise your child's IEP and make changes as an IEP team. All relevant members of the IEP team should be present for this meeting. This review can be to discuss a particular concern, for example, to discuss speech and language services or discuss a needed accommodation. The entire IEP does not necessarily need to be reviewed. There is no cost to the parent to use this option, and the meeting can be requested by the parent or school to resolve the issues at hand. When disagreements cannot be resolved through informal discussions with the school team, there are several options available to families and schools. Meeting facilitation is more formal than the informal meeting process. Meeting facilitation can be used as soon as a meeting is scheduled. Any special education meeting, such as an IEP meeting, a manifestation determination review, or a meeting to develop a behavior plan, can be facilitated. A neutral trained facilitator can help promote effective communication, keep the discussion focused on the issues at hand, and coordinate the conversation so all parties can share their thoughts and ideas. This process is voluntary. Both the parent and the school must agree to participate. The school or parent can ask for a meeting facilitator, and there is no cost to the parent or school to use meeting facilitation. Facilitation can be used when relationships are strained or participants are feeling uneasy about a meeting and would like a neutral third party to help steer the conversation. The meeting facilitator will develop an agenda based on input from the parent and school, stay neutral, facilitate the meeting if asked to, and keep the discussion focused on the issues at hand to help participants work through the disagreements. The facilitator makes sure that everyone follows the ground rules set forth at the beginning of the meeting and keeps track of the time. A facilitator is not part of the team, does not give legal advice, make decisions, or advocate for a particular position related to the issues being addressed. Mediation is available at any time, even if a state complaint or due process complaint has been filed. Mediation is scheduled at a mutually agreeable time where the parent and school choose to participate in a confidential guided discussion in a neutral environment facilitated by an impartial mediator. Mediation to address complex issues may require more than one session. This option can lead to an enforceable written agreement signed by both parties. Whether there is resolution to the issues or an agreement is created depends on the participants. The school district must ensure that the representative participating in the mediation has the authority to enter into a binding agreement on behalf of the district. And there is no cost to the parent or school district to participate in mediation. Mediation can be used for any disagreement, for example, related to eligibility for special education services, transition issues, placement, or communication issues. Mediation can help improve communication and relationships by assisting parties to focus on the specific issues of disagreement and talk through concerns for the purpose of reaching a mutually agreeable decision. The mediator is trained in mediation techniques and special education law. The mediator sets the ground rules, clarifies points of agreement and disagreement, takes notes during the meeting, and works with the parent and school to reach a mutually acceptable resolution to the issues of disagreement. If an agreement is reached, the mediator will record the agreement. The mediator will not make decisions, give legal advice, or take sides during the process. Parents or schools can request a meeting facilitator or mediator through Special Education Mediation Services, SEMS, which provides services at no cost to parents or schools. SEMS is an Individuals with Disabilities Education Act grant-funded initiative that uses trained facilitators and mediators who are not employees of the Michigan Department of Education, intermediate school district, or school district. SEMS is the state-approved option for mediation for special education issues. Parties can contact SEMS by phone or fill out a request for services form online. SEMS will gather the needed information about the child, school, and issues at hand, and will provide information about how their services may help the situation. SEMS contacts the other party for agreement to participate and will coordinate with the local resolution center to arrange a mutually agreeable date, time, and location to meet. SEMS processes all the necessary paperwork, and the parties meet to work together to resolve the issues. What if you've met informally or as an IEP team, used a meeting facilitator, or participated in a mediation session and the issues you disagree with the school about are still not resolved? You may consider filing a state complaint. Anyone can file a state complaint when they believe there is a concern about a particular child, including organizations if they believe there is an issue that affects children statewide. State complaints are a written, signed statement that alleges a public agency, such as a school or school district, violated the Individuals with Disabilities Education Act or Michigan Administrative Rules for Special Education. These are the federal regulations and state rules related to special education programs and services, or violated an intermediate school district plan. These are the district plans about how they will provide special education services, or the Michigan Revised School Code as related to special education, or decisions made by an administrative law judge through a due process hearing, or the state application for federal funds. State complaints can be filed for a variety of reasons. Some examples of issues that could be addressed through a state complaint are a parent was not invited to an IEP meeting, the IEP is not being implemented, the district did not respond to a parent's written request to evaluate, the evaluation was not completed within the timeline required, programs and services are not appropriate, or the district didn't allow a parent to see the child's records. Issues that were previously decided in a due process complaint involving the same parties cannot be investigated through a state complaint. An individual complaint is used when a complainant believes a school or an intermediate school district violated a special education rule or regulation for an individual child and wants a remedy called a corrective action for that child. A systemic complaint can be filed when the complainant believes the school or the intermediate school district violated a rule or regulation for a group of students, or a district-wide policy or procedure violates a special education rule or regulation, and they want a school or district corrective action. A state complaint must be received by the Michigan Department of Education, Office of Special Education, within 1 year of the alleged violation. The state complaint process must be completed within 60 calendar days from when the complaint was filed, unless there is an approved extension due to exceptional circumstances or mediation. The parent and school may agree to participate in mediation at any time without stopping the 60-day timeline. However, the parent and school may make a written request to the Office of Special Education for an extension when engaging in mediation through special education mediation services. Mediation can occur at any time during the state complaint process. The Individuals with Disabilities Education Act allowable timeline extensions are determined by the Michigan Department of Education, Office of Special Education. Staff shortages, heavy caseloads, school vacations, and breaks do not meet the criteria for an exceptional circumstance for an extension. Investigators review the information related to the complaint and may interview people by phone or in person, send questionnaires, review documents, and conduct on-site visits. The investigators make findings and a determination based on applicable law. There is no cost to the party filing the complaint. The investigation and decision are paid for at public expense. This is the only dispute resolution option that is open to any person or organization, including those not related to the child. No appeal to the state complaint final decision is allowable in Michigan. A due process complaint can only be initiated by a parent or the school. This is the most adversarial dispute resolution process. It specifically addresses issues related to violations of the Individuals with Disabilities Education Act and Michigan Administrative Rules for Special Education around identification, eligibility, placement, a free appropriate public education, and discipline, a manifestation determination review decision for a child with a disability. A due process complaint must be filed within 2 years of when the party knew or should have known about the problem. A meeting of the parties, called a resolution session, must be held within 15 calendar days of filing the complaint, unless both parties agree not to have the meeting or to use mediation instead. The resolution session is one last effort for the parties to try to resolve the issues without going to a hearing. If the school files a due process complaint, there is no required resolution session. If the issues are not resolved, parties go to a hearing. This is an administrative hearing in a legal setting with a hearing officer, administrative law judge, evidence presented, legal arguments, witnesses, and testimony. The result of this hearing is a legally binding decision and order made by the administrative law judge. Attorneys represent school districts. Parents can be represented by attorneys. Each party pays their own expenses. Within 75 days, the final decision and order are mailed. There could be an extension of this time frame at the request of the parent or school and approved by the administrative law judge. An appeal to the decision and order can be made to civil court. An expedited due process hearing is used to appeal a district's manifestation determination review decision related to discipline and placement. This is the only reason stated in the Individuals with Disabilities Education Act for which an expedited due process hearing can be requested. An expedited due process hearing is the same as a standard due process hearing, except that the timelines for the resolution session, hearing, and decision and order are shorter. The complaint must clearly state that an expedited due process complaint is being filed. A request for an expedited due process hearing can be made, but ultimately the administrative law judge will decide whether it is expedited or not. Parties pay their own expenses in this process. If you are filing a due process complaint regarding a disagreement with a placement change or appeal to a manifestation determination review decision, student must stay put in current placement pending the results of the hearing unless parent and school agree on a different placement. This chart is a summary of the dispute resolution options that I just discussed, including questions to consider when choosing which option to use. These are some resources that may be useful to you as you are considering dispute resolution options. If you're not familiar with it, the Michigan Department of Education Office of Special Education Information Line is a great resource for your questions related to special education in Section 504 topics. Family Matters is a resource page with one-page fact sheets developed by the Michigan Department of Education Office of Special Education for parents and families. These are the fact sheets relating to special education problem solving, meeting facilitation, mediation, as well as many other topics. I talked about special education mediation services, and this is the information for the online request form. And Disability Rights Michigan is a private, nonprofit, nonpartisan protection and advocacy organization authorized by federal law and state law to advocate and protect the rights of people with disabilities in Michigan. Our comprehensive website includes up-to-date information and resources about special education and disability-specific topics, links to our recorded videos, and information about how you can sign up for our monthly e-newsletter. We share information on social media and offer statewide virtual events and learning opportunities throughout the year. Our materials and events are always free to parents, caregivers, and educators. Michigan Alliance for Families' greatest asset is our regional parent mentors and information and referral staff around the state who are here and ready to help you. Regional parent mentors provide individualized assistance and are available to talk to parents and professionals about special education and related services. Find your regional parent mentor on our website by going to the About Us tab or by calling 800-552-4821. When you call this number, you will be sent directly to the regional parent mentor in your area. Thank you again for joining me today. Michigan Alliance for Families is an IDEA grant-funded initiative of the Michigan Department of Education Office of Special Education and Michigan's Federal Parent Training and Information Center, funded by the U.S. Department of Education Office of Special Education Programs.